very much for joining us for the second series of European law interviews on the internal market. These interviews are sponsored by the Jean Monnet Chair, which is part of the European Commission program promoting innovating learning patterns related to EU studies. We have the great opportunity today to interview Professor Nicolas de Sadeleer. He is Professor in European and Environmental Law at Université Saint-Louis Brussels and Université Catholique de Louvain. Good morning, Professor.
Hello, nice to see you again.
Nice to see you again too. Today we will briefly discuss the issue and the notion of the principle of proportionality. So the first series of interviews on the internal market was focusing on Article 34 and 35 of the TFEU, so on measures having equivalent effect to quantitative restrictions on imports and on exports. Then we discussed Article 36 in the rule of reason, so grounds of justification for measures hindering trade. Today we will discuss the principle of proportionality and the assessment of proportionality in order to avoid abuses and hindrance to the principle of free movement of goods. We will start with a very broad question, Professor. Can you please tell me a bit more about the origin of the principle of proportionality?
Yes, at the outset, the treaties of the CECA or the Treaty of Rome did not mention whatsoever the principle as such. The principle was developed by the Court of Justice in the early 1970s, taking into consideration case law development occurring in Germany. So in particular, one must stress that the German Constitutional Court has been developing a principle of proportionality as an unwritten constitutional principle with a view to reviewing legal acts that were likely to infringe basic rights. In addition, the principle of proportionality is also embedded in German administrative procedural law. Paragraph 113 of the German procedural code enshrines the principle of proportionality that has been applied by the German administrative court in reviewing administrative acts. In addition, one must also stress that the Court of Justice has been influenced by the case law development of the Conseil d'État de France, in particular the case law Ville Nouvelle Est, where the commissaire du gouvernement Guy Brébant highlight the necessity to apply a cost-benefit analysis test in reviewing the soundness of major development impinging upon property rights. So all in all, there are different sources explaining the willingness of the Court of Justice to proclaim the principle of proportionality as a general principle of law.
So you just mentioned the notion of general principle of EU law. What are the advantages for the Court of Justice to qualify the proportionality principle as a general principle of EU law?
This is a very salient question. Indeed, a general principle is, generally speaking, an unwritten principle. So it's a very powerful device in the arsenal of the Court of Justice while reviewing the legality of decisions or legislative acts. So given that it's a general principle, it can be applied into different areas, ranging from the validity of acts in the field of food safety, of the risk entailed by some products, or in the area of competition law, and so on and so on. So there is no borderline, and the methodology applied by the Court of Justice or the General Court while implementing the principle is likely to vary. So it's a rather flexible principle thanks to the fact that it's deemed to be a general principle of law.
You just said that general principles are normally unwritten, but is the principle of proportionality encapsulated in treaties?
Yes, the drafters of the treaty in the course of a revision took the advantage to proclaim it under Article 5, paragraph 4, that gives a definition to the principle. In addition to this, in primary law, there is also a specific protocol dealing with both subsidiarity and proportionality.
Okay, and then what are the functions of this principle?
Well, in a nutshell, the idea is to protect vested interest while reviewing the soundness of an action carried out by public authorities. In other words, the courts are there to review whether a public act is not impinging to a too greater extent upon the hardcore of a protected interest, such as the freedom to carry its own business, or the free movement of goods, or the free movement of services, or the free movement of capitals, you know?
Okay, thank you. So this brings us to another question. So basically, how does the nature of scrutiny by the court differ between the review of national measures impairing free movement of goods and the review of EU measures, basically?
Yeah, according to some critics, the Court of Justice endorses a double speech in that connection. On the one hand, the Court of Justice applies a rather strict test while reviewing the proportionality of measures endorsed by member states but hindering free movement of goods, whereas the Court of Justice applies a far more lenient test while reviewing measures endorsed by national authorities. The court perhaps is carrying out that two-pronged approach, given the fact that national measures impairing free trade are of utmost importance. And so the court is ready to apply a very strict test toward these measures. Whereas the measures adopted by the EU institutions do benefit from a presumption of legality, and as a result, the Court of Justice is less likely to nullify them.
Okay, so if I understand you well, the proportionality principle is a very flexible and evolving principle.
Indeed.
So
indeed.
there is no clear-cut definition.
Well, the doctrine is there. You know, there are university professors, lawyers on this continent ready to try to classify, to shed light on the different tests that the Court of Justice is likely to apply in reviewing the legality of national or EU measures.
So the Court of Justice is using tests in order to assess proportionality. We often refer to the suitability and adequacy test. Can you please explain this test for measures and especially the use of the objective pursued?
Well, it's difficult to decipher the case law. In some cases, the Court of Justice applies a three-pronged approach, whereas in the vast majority of the case, the Court of Justice satisfies itself in applying just the adequacy and the necessity test. In connection to the three-pronged approach, FEDESA is a good case in point. FEDESA case relates to the prohibition endorsed by the Council of Ministers of a number of hormone substances. Firstly, the claimants argued that the prohibition was inadequate on the ground that such a prohibition was likely to create a very dangerous black market, you know. Secondly, the claimants argued also that it was possible to assuage the fears of the consumers in providing better advice or better information instead of banning the hormonal substances. Thirdly, the producers of the hormones argued that the prohibition was entailing an excessive restrictions to their trade, to their production. In particular, they were suffering considerable financial cost accruing from the prohibition. But all in all, the vast majority of cases relate merely to the two first tests. On the one hand, adequacy, on the other, necessity of the measure.
Okay, so this adequacy test is often seen as very abstract. Do you mind re-explaining the notion, especially for students watching us?
You know, the idea is that one should not kill a fly with a sledgehammer, or one should not break a butterfly on a wheel, as the saying goes. So the core idea of the adequacy test is that the national measure must be deemed to be adequate, must be deemed to be suitable in order to achieve the environmental protection goal or the health protection goal. So the question arises as to whether the facts, the scientific facts, justify the need for action regulating trade in goods. So the national authorities should assess whether their measures is likely to remove the nuisance, the pollution, or the environmental risks. And the more coherent, the more consistent, the more intelligent the measure is, the more suitable the measure is likely to be. So of importance for national authorities is to assess the consistency, the systematicity, and the suitability of the measure in order to explain the link of causation between the scientific facts, the hard facts, and the objective being pursued. So it's basically speaking to provide for a clear link of causation.
Okay, and then do you have an example of an environmental measure fulfilling this first condition?
Well, the deposit and recycling German scheme for water bottles is a good case in point. The Court of Justice ruled in two judgments that the scheme was adequate in order to reduce the amount of waste produced in Germany.
Okay, so if I understand you well, this proportionality principle implies a comparison of measures capable of attaining a desired result.
Yeah, that's a necessity test, so it's a second step.
And so if the court finds a measure less trade hindering, it will consider that the measure adopted by the member state is not necessary and disproportionate, isn't it?
Yes, the court is likely to compare between the various alternative measures and to select the measure that is likely to hinder to a lesser degree the trade in goods within the EU. On the one hand, it's an issue of comparison. Mm-hmm. On the other, it's an issue of selecting the most advantageous measure, advantageous for trade.
Okay.
Not in particular for the environment.
Okay, thank you. And then what is the ratio of the necessity test?
Well, the question arises as to whether the alternative measure can meet the target, can fulfill the objective, while hindering to a lesser degree the trade in goods within the EU. So the question is whether advertisement of the danger of a product is hindering to a lesser degree the trade in goods than a ban and a genuine prohibition of the products.
Okay, and then do you have an example of an environmental measure fulfilling the second condition?
Well, with respect to nature conservation, the Belgian nature conservation authorities obliged during a number of years the traders to place metallic rings on the legs of birds such as greenfinch, hawfinch, chaffinches, goldfinches, you know, all these wonderful birds, and they apply that measure with a view to avoiding huge frauds in the system. The European Commission took an action for infringements against Belgium on the account that the Belgian measure, firstly, was a measure equivalent to an obstacle to trade. But in addition, the Commission claimed that the measure was disproportionate on the ground that it was possible to replace the metallic ring by a plastic ring or by microchips. And the Court of Justice endorsed the views of the European Commission, given that it was possible to have a different kind of rings to mark the birds. The Belgian measures was deemed to be disproportionate. But as a matter of fact, it's much more easy for the traders to replace the plastic rings by illegal or to produce illegally plastic rings. So the measures advocated by the Commission is far less efficient than the former Belgian measure.
Thank you very much. And do you have another example in the area of waste management?
Danish bottle case is a good case in point. The Danish authorities in the course of the 1980s endorsed a rather tough waste management policy, in particular with regard to bottles, and they obliged the manufacturers or the importers not to recycle but to reuse the bottles. And of course, reuse obligations are likely to hinder trade to a greater extent than recycling obligations. So recycling obligations are much more favorable to traders, you know. So the Commission, before the Court of Justice, advocated, in the light of the necessity test, that the reuse obligation had to be replaced by a recycling obligation. And the Court of Justice took the view, in its judgment, that the reuse obligation was not only adequate to achieve the objective, but in addition, the recycling obligation were likely to be far less efficient in order to achieve the waste management objectives.
So many factors have to be taken into account, and member states have the possibility to choose between a wide range of measures. So basically, how can the courts control the necessity of a public authority intervention?
It must be noted at the outset that the national authorities are called on to compare the different alternatives that are likely to meet the target. So firstly, there is an issue of comparing a broad range of measures, from prohibitions to advertisement, that are likely to achieve the objectives. And whenever the measures is deemed to hinder trade, national authorities are called on to look at them very carefully and to assess whether they could be replaced by less stringent measures. The question arises as to whether the member states can choose between different measures. In particular, when the risk is deemed to be very significant, is it really possible to replace the most salient measures by far less sufficient measures? You know, when the health of the worker is at risk, does it make sense to replace it by a measures that's not likely to achieve a high level of protection?
Okay, thank you. So going back to courts' assessments, how can we reach the conclusion that a measure is more effective, more proportionate, or even less restrictive?
Well, of course, politics, in particular national politics, is not rocket science. National authorities do have to juggle with various competing authorities, as you stressed a few minutes ago. And there is a gap between law in practice and law in the books, as you're aware. In connection to national measures, it's fairly difficult to determine whether that specific measure is much more effective or is far less effective than another kind of measure. In particular, while the court is reviewing the proportionality of national measures, the court is not endowed with technical expertise or scientific expertise to decide that kind of measures must be set aside on the ground that it's hindering to a greater extent freedom of trade.
Okay, and then let's move on. So within the EU, we have different levels of protection. So it's not the same, for example, in Portugal and in Sweden. So can you please tell me and answer the following question? So are the member states required to apply the lowest level of protection?
That sounds music to my ears. The fact of the matter is that whenever a member state is applying far less protective standard, that doesn't mean that the highly protective standards of another member states are disproportionate in their own right. So the fact that one is facing variations as a matter of safety does not undermine the soundness of the national measures endorsed by countries like Sweden or Germany that are seeking to achieve a very high level of workers' environmental or health protection.
Thank you. My last question is related to the neutrality of the necessity test. Is it really deemed to be neutral?
As a matter of principle, the principle of proportionality is deemed to be neutral. It's not supposed to hide subjective assessment. The Court of Justice is not there to carve out an hierarchy of values out of thin air, you know. In addition, environmental interests should not prevail over economic interests. Conversely, economic interests should not prevail or supersede environmental interest. However, as a matter of practice, one realizes that the Court of Justice is regularly comparing apples and pears, and that the test of necessity is actually intertwined with a stricto sensu proportionality test, and that the Court of Justice is actually, in applying the test, hiding subjective assessments.
Okay, thank you. So basically the Court of Justice often held incompatible measures not giving enough time to companies to adapt to a regulation. So are member states obliged to give sufficient time to private operators and companies, for example, so that they can adapt to the new standards?
Well, I won't say that the member states are obliged to take into consideration time limits, but of importance, it's to give sufficient time to the traders or to the economic operators to allow them to adjust their production, their marketing approach. A good case in point is the German deposit and recycling scheme. The Court of Justice decided that the scheme was deemed to be disproportionate on the account that there was a 6-month difference between the announcement of the measure and the entry into force of the measure. And the Court of Justice took the view that 6 months was not enough for the producers and the importers to adjust their production lines.
Thank you. Then is it possible to review the proportionality of a restrictive measure when there are no alternatives?
Well, it doesn't make any sense. One should not compare apples and pears.
Okay, that's very clear, thank you. Then member states might use a positive list approach and then a negative list approach. The positive approach is a bit more restrictive. So can you please answer the following question? How can member states comply with the proportionality principle while regulating products through positive listing?
Yeah, well, this is a very complex question. As you were stressing, there are two approaches regarding listing of substances, animals, articles, goods, and so on. The more classical approach and the more favorable approach to traders is negative listing. So the substances listed in the annex of the directive or the regulation or the national decrees cannot be placed on the market, they cannot be used, or their use is being restricted. And so the traders are aware that they can trade or they can place on the market all goods, all articles, but the ones that are listed. CITES is a good case in point in that connection. In the annexes of the CITES regulations or the CITES conventions, well, one finds the chimpanzee or the gorilla, and one cannot trade in these animals, as you are aware. Positive list is a totally different approach. You know, the member states prohibit everything but what's on the list. That means that trade in goods is restricted to a greater extent, and so a positive list approach is more likely to hinder trade in goods within the EU than a negative list approach. That being said, the Court of Justice does accept that member states apply or endorse a positive list approach in order to tackle environmental risk or health risk. And so one finds positive list in the area of food safety or in the area of nature conservation. But the Court of Justice has been setting out different criteria, among which the member state must lay down a procedure that's deemed to be transparent, objective, and that allows the traders to propose to the national administration to add new substances or to add new animals or new species on the list. And state authorities are obliged to review the request, to take a decision, and to state the reasons of their decisions. And the member states can reject the proposals made by the traders on the ground that there is a genuine risk to the environment. So, for instance, in connection to the animal protection, it's possible for member states to endorse a positive list approach, taking into account the ecological needs or the ethological needs or the physiological needs of the animals. But the member state must have to comply with the different conditions laid down by the Court of Justice.
Okay, then, and in your view, how can member states enhance the effectiveness of their measures?
Well, they must base their measures on sound science. So the fact of the matter is to reckon upon sound risk assessments demonstrating the link of causation between the substance and the risk that's likely to occur, and to demonstrate also that another less effective measures is not suitable to replace the sound national measure. So of course such tests do apply strong involvement on behalf of the state authorities. And my view is that science is of paramount importance, but in addition to science, member states should also stress the consumer needs, the risk of fraud, so the extent of the black market, the risk of traders or consumers violating, infringing the national regulations, and so on and so on. And so, in addition to the genuine scientific risk assessment approach, the member state can also reckon upon sociological studies or market studies to demonstrate that the measure at issue is the most tailored one, is the most systematic one, is the most suitable one to achieve the target.
Okay, thank you. This leads us to another question. Are member states on the safe side where the banned products can be replaced by substitutes?
Yeah, I imagine Tulex is a good case in point in that connection. The chemical inspection in Sweden, the agency dealing with chemical risk, decided to ban in the industry the use of trichloroethylene, a substance that's deemed to be carcinogen. And at that time, there was a possibility to replace the substance by a number of substitutes. And the chemical inspections provided for a specific procedure in order to allow the producers, in order to give them sufficient time to replace the trichloroethylene by this other substance. So the companies were called on to apply for exemptions during a specific period and explain the manner in which they would replace trichloroethylene by other substances. And in reviewing the proportionality of the Swedish ban, the Court of Justice took into consideration and paid heed to the substitution process. So whenever there is a possibility for traders to replace the very dangerous substance by a substance that's deemed to be less hazardous, it's a good point for the member states.
Okay, thank you. So, as far as the environment is concerned, EU law and international law are closely intertwined. So, the EU and member states might have to adopt measures in order to comply with their international obligations arising, for example, under CITES or the Basel Convention. They also have obligations under secondary law. So, my next question will be, Professor, are the EU secondary law and international law obligations taken into account while assessing the soundness of the restrictive measure?
Practically speaking, member states are obliged to comply with a huge number of multilateral environmental agreements, as well as with a huge corpus of secondary law that entails hundreds of directives and a big number of regulations. So, of course, all these legal acts grant to the member states some leeway. Member states' authorities are likely to apply higher standards than the ones provided for under the international agreements or under secondary law, in particular when the secondary law acts are based upon Article 192 of the Treaty on the Functioning of the European Union. But of course, in so doing, the member states are likely to jeopardize free trade in goods within the EU. My view is that whenever the national measure restricting trade is enacted with a view to fleshing out the obligations laid down in international law, mixed EU agreement, or in secondary law, the Court of Justice must pay heed to that kind of obligation. But it has not always been the case.
Let's move on to the case law of the European Court of Justice. We see, Professor, that in some cases the court decides itself to assess the proportionality of a measure, and then in other cases the court simply refers the case and sends it back to national courts and consequently let them assess the proportionality of the measure. So in your opinion, what should the court do?
Well, it's rather a rule of thumb than a rule of law. Nothing is said in the treaty regarding preliminary reference whether the Court of Justice has to decide the reviewing of proportionality or has to give merely guidance to the national courts. So whenever the Court of Justice feels uncomfortable on the ground that it has no access to all technical, economic, scientific data, the Court of Justice is likely to refer the final decision on proportionality to national courts. However, in a number of very important cases, the Court of Justice took the view that the evidence was clear, and the court just ruled on proportionality in its own right.
So you mentioned the Fedesa judgment earlier. In this case, the court introduced a new test called proportionality test stricto sensu. Can you please explain this third test and the ratio of such a test?
Well, frankly speaking, my view is that in Fedesa, the Court of Justice endorsed the claimant's argument. The claimants highlighted the three tests. Later on, Advocate General Van Gerven, as well as other Advocate Generals, have been advocating for a three-test approach. But in the vast majority of cases, the Court of Justice merely applies the adequacy test as well as the necessity test. So the approach is rather different than the one endorsed by the Human Rights Court in Strasbourg. The Human Rights Court in Strasbourg is likely to apply a stricto sensu proportionality test in comparing the way of the different interests, antagonist or conflicting interests. In Luxembourg, the Court of Justice so far has been much more reluctant to endorse such an approach. The Court of Justice's view is that the hierarchy of interests must be laid down either by the national lawmaker or by the EU institution. It's not the business of the Court of Justice to decide whether that kind of interest should prevail or should supersede over an antagonist interest. That being said, the General Court is more ready to endorse a stricto sensu proportionality test. Needless to say that this last test is extremely controversial, is dogged by controversy. The question arises as to whether a General Court or a Court of Justice can really replace the lawmaker.
Okay, thank you very much, Professor. This is the end of our first interview of this second series of European law interviews. We will discuss today the principle of proportionality. We started by discussing the origin of this principle. We went back to German law and French law. Then we introduced the notion of general principle of EU law and mentioned the fact that even if the principle is unwritten, it is encapsulated in the treaties. Then we went through the functions of the principle and the different tests used to assess proportionality, so the suitability, adequacy test and the necessity test. Then we gave you several examples, for example on waste management with the Danish reusable bottles case, and on nature conservation with an example on wild birds in Belgium. We then decided to analyze the neutrality of this test, and finally went through the case law and at the end of the day introduced this new proportionality test, stricto sensu, which is very controversial. We will see you next week for a second interview in this series on taxes and harmonization. Thank you very much. This program was sponsored by the Monnet Chair. See you next week. Bye.